Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for arraignment. Now, arraignment basically is the first opportunity that you will be in court. And it is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are referred to as your more serious type of criminal offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not as serious, it just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the case. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment, if the person is convicted, is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishments. Misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. And the fine cannot exceed or be above $500. You cannot get any jail time. Now, for example, a Class C misdemeanor, those cases start in the city court or the justice court, the JP court. An example of a Class C misdemeanor is a speeding ticket, not having your seatbelt on, or not having a proper inspection sticker. Those are Class C misdemeanors. Now, I said that they start in the JP court or the city court. They come to this court if a person is convicted in one of those courts, and then that person appealed their case. What I mean by appeal is they're asking for a new trial. And the case comes here. They get a whole new trial. They start all over. And the punishment does not change. It's still the same. It cannot be a fine that exceeds $500. Now, if the person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capious pro fine. Capious pro fine means it's a warrant for their arrest to either pay the fine or sit the fine out in jail. And if they sit the fine out in jail, they'll be credited at $100 per day that will go toward the fine and the court costs. Now, the next highest misdemeanor is a Class B misdemeanor. We have A, B, and C, so the next highest misdemeanor is a Class B misdemeanor. For the Class B misdemeanor, the range of punishment is minimum $0 to a maximum of $2,000, or you could be given jail time that starts from 0 days to a maximum of 180 days, or you could be given both jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is minimum 0 days in the county jail, just like the Class B is 0 days in the county jail to a maximum 180 days in the county jail. The Class A misdemeanor, 0 days to a maximum of 365 days, which is a year in the county jail, a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is unadjudicated probation, and the other type of probation is adjudicated probation. I'll explain the difference between the two. With unadjudicated probation, and we commonly refer to it as deferred probation, it does not result in a conviction on your record. And if you successfully complete that probation, the case will be dismissed, and you may qualify for what is called a non-disclosure. And what a non-disclosure is, it basically means that the court, we cannot disclose the fact that you were on deferred probation to the general public. Now, the operative word that I use is general public because there are governmental agencies listed in the Texas Code of Procedure that can't have access, but most of the public is general public, so they cannot have access to it. So your record is sealed to the general public. The other type of probation is adjudicated probation. Adjudicated probation. And with adjudicated probation, it does result in a conviction in your record. However, there is something that is called judicial clemency, where the judge can set your conviction aside and you will no longer have a conviction. Now, in order to qualify for judicial clemency, three things has to happen. One, you have to successfully complete probation. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged off of the probation or let off the probation by the probation department. And if those three things happen, the court can set your conviction aside. The court has discretion to set your conviction aside. And if your conviction is set aside, it won't appear on your record. Okay? Now, however, if you get a subsequent conviction, or if you get a second conviction or another conviction later, then the case that you received judicial clemency on can be brought back up. It could be resurrected, revived, brought back up, and it can be used against you. And if you tried to get a license with Child Protective Services, they could either deny giving your license, or if you have a license, they could suspend or revoke your license. All right. Now, everyone should have a clipboard. Everyone in here, I'm going to go over the paperwork on that clipboard. Now, the first document that I'm going to go over, this is the main document. It's called Judge's Explanation of Rights to Defendants Without Attorney. Make sure everyone is looking at this document. We're going to, when we finish going through this document, everybody's going to sign. You're going to put your initials on one of these 5 lines at the bottom. You're going to sign your date. All right. At the top of this document, it states that as a defendant in a criminal court, in a criminal case, you have 3 options three options regarding your right to have an attorney. And it starts about number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first paragraph, the first one sentence paragraph below number three states this: if you want an attorney and you have enough money to hire an attorney, your case will be reset to give you time to hire your lawyer. Reset means that you'll be given another court date from the day. You'll be given time to hire your attorney. The next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. In essence, you can ask the court to appoint an attorney to represent you. But you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the financial questionnaire, this is only for people who will be asking for a court-appointed attorney. If you're not asking for a court-appointed attorney, you don't have to worry about this financial questionnaire. All right? If you would like to apply for a court-appointed attorney, you need to look at a document that is titled Jefferson County Affidavit of Indigence. It is a 3-page document. Okay? 3-page document. Okay, we're going to look at the first page. You would have to fill out the first page. At the bottom of this first page to your left, there's some financial information that you have to fill out. If you work, if you don't work, make sure if you don't work, just put 0. If you get governmental benefits, you put that. If you're not, 0. And then you total it at the bottom. If it's all zeros, it's 0 total. On the right side at the bottom, it asks for your bills. You know, like if you have to pay a rent, mortgage, or for your food expenses. And we're going to give you time to fill this out. You don't need to fill it out right now. On the second page of this document, you'll fill out the top portion that is titled Defender's Oath. That's the top portion. It says Defender's Oath. And you fill out the date and your date. You'll read that and you put the signature on it. And then you'll fill out the middle portion where it says Unsworn Declaration by Defendant. Is right here. Unsworn Declaration by Defendant. Once you fill it out, you'll stop. And then you won't have to fill out anything else. All right? That's for people who will be applying for a court-appointed attorney. Now, if you don't want an attorney to represent you, if you want to represent yourself, you have a right to do that as well. And if you represent yourself, you'll have an opportunity to talk to one of, we call them prosecutors or assistant criminal district attorneys. You have an opportunity to talk to one of them about your case to see if y'all can work out a settlement on your case. The reason why you'll have an opportunity to talk to them is because you'll be waiving your right to an attorney, giving your right to, you will be representing yourself. You'll be acting as your own attorney. So just like an attorney can talk to the state or the prosecutors or the assistant criminal district attorney, you can do the same thing. Why? Because you're your own attorney. Now, you'll have an opportunity to talk to one of them about your case. Now, you would have to fill out, if you would like to, the paragraph states that you may not speak to the prosecutor. That's the third paragraph, the third one sentence paragraph, unless you first fill out a waiver of counsel. Now, a waiver of counsel, now this is only for people who will be representing themselves. If you're not representing yourself, you don't have to worry about this. So if you're a hired attorney, you don't have to worry about it. If you apply for a court-appointed attorney, you don't have to worry about this. Only people who will be waiving their right to an attorney and represent themselves will fill out this document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. It's a one-page document, and you have to read this document, sign and date. All right. So just as a brief recap, no, before I do that, now, those of you who will be representing yourself, now at the bottom of this document, in block form, there's a paragraph. It states that be aware of the dangers and disadvantages of self-representation. Waiving your right to an attorney representing yourself may result in the worst outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. And the last paragraph, before we get to the bottom, it states, and this is for people who will be representing themselves, it states that if you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you're representing yourself. Let's say you talk to the prosecutor. Let's say you want probation, but they're offering jail time. You say, well, I don't want that. I don't want to represent myself. I want a lawyer. You have a right to do that. Okay, that's just an example. Now, at the bottom of this document, everybody, there are 5 lines to the left where you put your initials. Everyone here who's here for a case is going to mark their initials on one of these 5 lines. That'll put you in the category that you're in. Okay, at the top, it says defendant's choice. Mark initials next to only one choice. Now, if your choice is to hire an attorney to represent you, to hire an attorney, you'll place your initials on the first line to the left, right here at the bottom. Put your initials there. If you want to hire an attorney, and then you'll sign and date it, and then you'll stop. And this will be the only document that you have to sign if you are hiring an attorney. All right. Now, if you've already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Okay, it's the second line. If you already hired an attorney, place your initials on the second line to the left and the name of the attorney on the line to the right, on the second line. All right. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. Okay, on the third line. Then you'll sign and date it, today's date, September 9th, 2025. If you've already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you would like to waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left, okay? And then you'll sign and date it today's date, and today's date is September 9th, 2025. Okay. Do we have any questions? Okay, so you're going to be in one of the 3 categories. One, you want to hire an attorney, and if you want to hire an attorney, this is the only document that you have to initial and sign. If you would like to apply for a court-appointed attorney, then you place your initials on the third line, the first document, and then you sign the first page, fill out the first page, and then on the second page, you fill out the top portion that's titled Defendant's Oath, and the middle portion that is titled Unsworn Declaration by a Defendant, and then you'll stop. If you would like to represent yourself, that is, waive your right to an attorney, you'll place your initials on the fifth line at the bottom of this document, sign and date it, and then you'll fill out the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay. All right. Now, and we're going to give you time to fill out the paperwork once we finish. Next, as a defendant in a criminal case, you can enter one of three types of pleas. Okay. For example, you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest, or no contenders, no contest. And what that means is you're telling the court that you will not be contesting or you will not be fighting the charges. All right. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Where Mr. Stewart is sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. In essence, they will listen to all the evidence that's presented in the court. They'll listen to arguments by the lawyers, and then they'll go into the back room, the jury room, to deliberate, and they will decide to find you either not guilty or guilty of the charges. You also have a right to waive or give up your right to have a trial by jury. Now, if you waive or give up your right to have a trial by jury, you can have a trial. You still can have a trial. The trial will be without a jury. We call that a bench trial. And with a bench trial, the reason why they call it a bench trial, because the judge sits on the bench. And so the judge will be the judge and the jury in the case. Okay? The judge will listen to all of the evidence. The judge will listen to the arguments of the lawyers. The judge will apply the facts to the law. And then the judge will decide to find you either not guilty or guilty. Now, you also have a right, well, not necessarily, you're going to have an opportunity to talk to the prosecutor to see if you can work out a plea bargaining agreement. Okay? For example, you can have what is called an agreed plea bargaining agreement. An agreed plea bargaining agreement means this. It means that you and the state have reached an agreement concerning your punishment. So, for example, let me use the same example I used earlier. You wanted probation. The state offered you probation. You say, oh, that's agreeable. I'll take that. And then we call that an agreed plea bargain. If you have an agreed plea bargain, it has to come before the court or the judge, and the judge could do one of two things. The judge could accept or reject your plea bargain agreement. Now, if the judge rejects your plea bargain agreement, you have a right to take back or withdraw your plea of guilty or no contest. You can say, well, judge, since you're not following or going along with the agreement that I made with the state, I take my plea of guilty back or my plea of no contest back. You have a right to do that. Now, if the judge does follow that agreement, and let's say within 30 days, you want to file a new trial, or you want to hold a new trial, why? Because you think you've been wrongfully convicted or the court committed an error by convicting you. And so you want to appeal your case. If you want to appeal your case, you have to get permission from the judge that followed the plea bargain agreement. And if the judge gives you that permission, your case will leave this court and it will go right upstairs to the 9th Court of Appeals. There are 4 justices up there, and they will review your case. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or if they deny your appeal, no problem, because you can appeal it to a higher court than the 9th Court of Appeal. You can appeal your case to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals, and they're located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. I'll explain that too. Pro se means I'm representing myself, pro se. Okay? And I'm petitioning, I'm asking the court in Austin to review my case to see whether or not my appeal should have been granted or whether or not this court wrongfully convicted me or committed an error by convicting me, they can do one of two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty and case is over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Orders could be to give you a whole new trial. Now, if they deny your petition, then at that point, your conviction will stand. All right. Now, the other right that you have a right to have what is called, well, the other option that you can have what is called an unagreed plea bargain agreement. Okay? What that means is this here. You know, an agreed plea bargain is like when you and the state come to an agreement. An unagreed plea bargain means that me and the state can't agree. I still would like to enter my plea of guilty and no contest. And so if that's the case, then it's unagreed, it goes before the judge. And then the judge will decide what your punishment will be. Okay? We call that an unagreed plea bargain. Now, the other right that you have besides right to have a jury trial, bench trial, or the options to have a plea bargain agreement or unagreed plea bargain agreement, you have a right to have witnesses to come to court. Now, when that young lady is sitting in that chair, we call that the witness stand. And witnesses, what they do, they come to court, they can testify. They can testify either for you or against you. Now, if you have a lawyer, your lawyer can ask them questions. If you represent yourself, you can ask them questions, and the state can ask them questions as well. Now, you also have a right to waive or give up your right to have a jury trial. Waiving or giving up your right to have a jury trial means that, not a jury trial, waiving or giving up your right to have witnesses mean that you don't want to have witnesses, you're not going to call any witnesses to testify in your case. You have a right to do that. Now, let me tell you this here. You need to make sure your phone's off. And if you waive your right to have witnesses, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have what we call a Fifth Amendment right against self-incrimination. And that simply means that in our United States Constitution, the Fifth Amendment, it gives you a right to remain silent. I know a lot of times we watch television shows like Law and Order, and we might see the television lawyer who goes up to the witness stand and asks the witness a question, and the witness says, "I take the fifth." What he's saying is, I'm exercising my Fifth Amendment right to remain silent. My Fifth Amendment right against self-incrimination. I don't have to incriminate myself. Okay? And I always use this example. It makes sense that you should have a right not to incriminate yourself. Why? Because the state has the burden of proof. The burden of proof is they have to prove you guilty. You don't have to prove yourself guilty. Right? They can't use you to prove yourself guilty. Right? So that's why you have a Fifth Amendment, the right to remain silent. I don't have to say nothing. The state, the government, the DA's office cannot force you to say anything. You can sit there and say, "Mom, Mom's, I ain't saying nothing." They can't force you to say anything. Okay? That's if you exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination, meaning that if you waive or give it up, that means you will be testifying in your case. All right. Now, you also have a right, what we call discovery. And what discovery is, you're using discovery to discover. You have a right to see the evidence or discover the evidence that the state has in its file. Okay? That's called discovery. You have a right to see your statements, witness statements, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings, you have a right to see. Have access to documents or instruments, whatever they have that they're using against you, you have a right to have access to that. That's called discovery. Now, you can waive or give up your right to have discovery, which means that you will want to have access to the evidence that the state will be using against you. Now, everyone here today for the case, you've been charged, you've been arrested, you placed in jail, you bonded out of jail, you're either out of jail on a cash bond, which means you paid the full amount of bond to get out of jail, or you're out on what we call a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released from jail under your own personal recognizance. I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. Now, the operative word is day. So let's say, for example, you were booked into jail at 11:59 p.m. last night, and you bonded out at 12:01 a.m. this morning, 2 minutes later. Okay? That's 2 days. I know you only been in jail 2 minutes, but they consider it 2 days because it's 2 different days. Okay? You don't have to be there 48 hours, 24 hours, it's 2 different days. So, for example, let's say now every day that you spent in jail can be used as credit towards your punishment. So if you spent 5 days in jail, the state is offering you to serve 5 days in jail, you don't have to serve any more time in jail because you've already spent 5 days in jail. Therefore, you'll be given credit for the time that you've already served. If they offer 7 days, you spent 5 days in jail, that means you only have to serve 2 days because you already have 5 days credit. You subtract 5 from the 7, that leaves 2. Every 1 day that you spend in jail can also be used as credit toward your fine and court costs. So you will receive $100 credit for every 1 day that you spent in jail. So if you spend 5 days in jail, that's $500 credit. If the state is offering you fine and court costs of $500, you spend 5 days in jail, you don't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, it will be taxed and retired. Now, if they offer fine and court costs of $700 and you spend 5 days in jail, that means you only have to pay $200 because we will subtract $500 from the $700. That leaves $200. Now, you'll be expected to pay the $200 or the balance on the day that you dispose of your case. But if you cannot pay it on the day that you dispose of your case, no problem, because we can put you on what is called a payment plan. And that simply means that you can pay it off in small monthly installments until it's paid. Now, if you do not have the income to pay it off in monthly installments, no problem, because we can convert your fine and court costs to community service. And for every 1 hour of community service that you perform at a nonprofit organization in Jefferson County, you will receive $12.50 credit toward your fine and court costs. So, for example, if you're $200, if you work 8 hours 1 day at $12.50, that's $100. So you work 2 days, 2 8-hour days, that's $200. You work 2 days, your fine and court costs is paid off. All right. Now, Jefferson County has a program for people who have not had problems, had not been convicted, have not had any criminal convictions. All right, it's your first time getting in trouble. Well, the program that they have is called pretrial diversion. And with pretrial diversion, they will dismiss your case and you can get it wiped off your record. And when I say Jefferson County, I'm talking about the district attorney's office. All right. Now, if you haven't been in trouble before, and you're interested in that program, and basically, in order to get in the program, you have to be your first time getting in trouble. 2, you have to have an attorney to assist you in getting into the program. An attorney could be a court-appointed attorney. Okay, they're just going to assist you with the application process. And then 3rd, It cannot be an offense for unlawfully carrying a weapon or resisting arrest. If those three things occur, first time getting in trouble, get an attorney, the offense is not resisting arrest or unlawfully carrying a weapon. You get into the program, they dismiss the case, you complete the program, you can get it expunged, which means wiped off, deleted, or erased from your record, like it never happened. All right? That's called pretrial diversion. If you are a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court for veterans only. And the person getting into that program, once they complete the program, the case is dismissed, and they can get an expunction, not an expunction, a non-disclosure, where your record is sealed to the general public. Now, and if you're interested in that, any one of those programs, just let us know, because we have brochures and people that you can talk to about getting into the program. Now, this court, County Court at Law Number 2 of Jefferson County, Texas, has a program that God led me to start in the first 100 days of taking office. The program is called the CSI program, also known as the Community Safety Initiative. That program is designed to address what is called the issue of recidivism. Recidivism means that people commit crimes over and over, it's not their first time. And so, how do we stop folks from getting into trouble over and over? Well, we have the CSI program. And with the CSI program, we have partnerships with local agencies. One of the agencies that we have a partnership with is our Spindletop Center. Spindletop is a local mental health center in our Southeast Texas region. And we have some folks from Spindletop who will come and talk to you a little bit more in a few minutes. And they're going to tell you more about the program. But basically, Spindletop will be able to do an interview, a private interview, either in our jury room, at their facility, by telephone, or whichever is convenient for you. They also can do an assessment to determine what the mental health issue is. And they can develop a treatment plan to address your mental health issue. Now, you do not have to be incompetent or insane to participate in the program. You can merely suffer from depression, anxiety, or any other mental health issues. Spindletop has expertise to address your mental health issue. Now, if you have a problem with drugs or alcohol, well, Spindletop has a program that is called ATAR, A-T-A-R. It's an acronym that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, O-S-A-R, which is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they'll do a screening, an assessment, and develop a treatment plan, either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, they will help you or assist you in getting a job in the area that you're trained in. If you have not graduated from high school or you do not have a GED, well, they have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time. We take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people would not commit crimes. Why? Because they have too much to lose. And so therefore, I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas. We don't just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know, because we can direct you to the people that you need to talk to get you started in this life-changing journey. Now, at this time, we have some folks from Spinatop. They're going to come right now and tell you a little bit more about the program. Like Caitlin, we have Deputy Barry and Deputy DeVilliers.
Yes.
Okay,
Thank you, Judge.
you're welcome.
Good morning, ladies and gentlemen. Like Judge said, my name is Trish Berry. I'm a deputy with Jefferson County Sheriff's Office. This is my work partner, Caitlin, and Deputy DeVille. So the reason that we're here today in this courtroom is the judge invited us in here because he cares about each and every person that enters this court. And statistics have shown that people who enter the criminal justice system, oftentimes they have mental health needs that are not being met, or substance use issues, or just simply a lack of resources. And that's what we're here to offer you today, is those resources to provide that step in the direction that you want to be in. You'll notice that on that clipboard, there's a small piece of paper in the very front. That piece of paper we have provided, it is strict voluntary. It's not mandatory that you fill out. This is not provided by the court. This is for us to be able to contact you if you wish to do so. It has good information. If you'll notice down at the bottom of it, there's also a crisis hotline, as well as a local office number for us. So my partner, Caitlin, is going to briefly explain how to fill this out. Again, it's strictly voluntary. It's not mandatory that you fill it out.
So most of the paper is pretty self-explanatory on how you fill it out, but if you're interested in mental health or substance use services, and mental health could be depression, anxiety, or PTSD, and substance use could be any type of drug or alcohol, then you can check the box. And if you want to talk to me about it today, you can write that on your paper too. And we can help you get into Spinatop services or any services within this area. It doesn't have to be Spinatop. There's doctors you can talk to, medications if you're interested, counseling, support classes or support groups. If you're interested in any of that and you want to talk to me today about it, like I said, please write it on your paper and you can check mental health or substance use. But if you want me to call you, you can just check call on your paper and I'll get to you within them.
Again, this is completely voluntary. If you have any questions, we're gonna come by in a little while, just kind of talk to you. If you have any questions, feel free to ask us at that time, even if it's not for you, if it's for somebody else, that's why we're here. Okay? Thank you, Judge.
You're welcome. Thank you. Okay, ladies and gentlemen, we have Mr. Johnny Stewart. He's with Family Services. He's going to tell you about a program that they have for individuals who have family violence cases, soft family violence cases. With the program, he'll tell you more about it as part of the pretrial diversion program as well, where if you get into the program, you complete the program, your case will be dismissed.
So I got a question. I got here for something different. No, I don't know if you the button for that.
If the what?
No, I'm sorry. I'm sorry.
Okay.
Thank you, Judge. Morning. I'm Johnny Stewart. I'm the BIP coordinator, director for Family Services of Southeast Texas. Y'all may know Family Services from the Women's and Children's Shelter, but we also have preventative programs. One of them is the BIP program, which is Batterers Intervention and Prevention Program. It's a program, so if it's your first time for family violence, you have an opportunity to enter this program and to complete it, and it will be part of the $3,000. This program, that's what one thing I like about this program, like about just it's about changing behaviors. If you get an opportunity to get into the program, it's going to not only change your behaviors with you, but also the relationship with your family. So please take advantage of this, because this is going to be a life-changing program that will keep you from coming back to this court or any other. So it's called, the Batterers Intervention and Prevention Program. I left some flyers over there if you're interested in it. So please take advantage of this if you are qualified for this particular program. And I appreciate your attention. Thank you very much.
Okay.
Thank you, Jim.
Okay, thank you, Mr. Stewart. At this time, we'll have Mr. David Cook. He's with Texas Care. He'll tell you a little bit more about the program that, Texas Care has to offer.
Hey, Judge. Good morning. My name is Dave Cook, and I'm a peer support specialist with Texas Care. The resources here that they provide in the court are super great. Done some work with Central Top, and, they're really here to help people. And, I've been in the courtroom, not this courtroom, but other courtrooms, and it's just nice to know that, that they actually care about your mental health and any other, drugs or anything else. We offer crisis intervention, skills and training and development, targeted case management, and evaluations and assessments and individual therapy. And we also work with children. So if anybody, that's interested in that, we work with children ages 3 to 17. There's some pamphlets over there, and I'll be here if anybody, there's also a paper on the clipboard if you're interested, and we'll get back with you and try to see if we can provide some services. But if you need any of the services, I would say take advantage of them, because I refer out a lot of these companies out, and it's super amazing what they do with nonprofits. And I'm just glad to be here, and I'm glad that the judge allows us in his court. So thank you.
Okay, now, ladies and gentlemen, the paperwork that you have, we're gonna give you time to fill out the paperwork. And then, if you need any help filling out the paperwork, we have our core personnel, including myself, who will be happy to help you to complete the paperwork. Now, if you need help with the paperwork, when we finish, we're gonna just simply raise your hand. And then we're gonna have our core personnel, some gonna come out, and then we're gonna ask some folks to come up, so we can help you fill out the paperwork. When you finish filling out the paperwork, fine, then you just raise your hand as well, that you know that paperwork is finished, and we'll pick the paperwork up. Now, it's gonna take us a little time to pick up all of the paperwork from everyone. Once it's picked up, then we're gonna ask you to come up before the bench, one at a time. You're gonna either be in one of 3 categories. One category, you want to hire an attorney. Another category, you want to apply for a court-appointed attorney. And the last category, you would like to represent yourself. Now, if you would like to hire an attorney, your case, as I mentioned to you earlier, will be reset, meaning they give you time to hire your attorney. If you like to apply for a court-appointed attorney, you pick the paperwork up, and if you qualify, you will be appointed a court-appointed attorney before you leave here today. And if you would like to represent yourself, you'll have an opportunity to talk to the prosecutor, and if you have to work out an agreement, fine, that case will be taken care of before you leave here today. Now, as I mentioned to you earlier, it'll take us some time for you to fill that paperwork up and for us to pick it up. If you need to use the restroom, there are 2 restrooms right out in the hallway. They have the male restroom or the men's restroom in front of County Court number 3. And on the opposite side of the hall, in front of the 172nd District Court, we have the women's restroom. You'll be allowed to use the restroom. And then you come back in court. Please do not leave the courthouse. If you leave the courthouse, and if your name is called, and if you're not here, a warrant is gonna be issued for you, your body's gonna be forfeited, and a warrant is gonna be issued for your arrest. And guess what? You're gonna be arrested. Gonna go to jail, probably gonna bind out of jail, and guess what? We're gonna have to go through this all over again. Okay, so we don't wanna do that. We wanna try to get we're gonna try to get this process done as quickly as possible. Okay? Okay, so at this time, the court will go into recess, and if you need some help, just raise your hand. We'll have someone to come out and talk to you. Okay?
Make sure you do not leave out without completing those documents. If you do, you will prolong the process.
Now, I forgot to mention this. At the top of the document, There's a line up here. Print your name on that, because the reason why I say print it is because a lot of times we can't tell who the person is from the signature. So just print your name right here on this here line at the top, okay? Okay, the court is in recess.
If you're done, I'll come around and I'll collect your clipboard. No, she's not gonna be have that. When you gonna have?
Ms. Jones, Astrid Jones. Ms. Jones, you could take your mic off of mute.
Yes, sir.
Okay, your case is being reset until October 14th, 2025. There's some paperwork that you would have to sign that you when you come in on that date. You understand? Your mic is on mute. Ms. Jones, you could take your mic off of mute.
Okay, there you go. I'm sorry about that.
Yeah.
You said
Yeah.
October the 14th?
Yeah, at October the 14th at 9 a.m. You need to come to court for arraignment so that you can, the paperwork that I went over in the court, you need to be here in person to sign that paperwork.
Yes, sir. Yes, sir.
Okay, so your case is reset to October 14, 2025 at 9 a.m. Stay in contact with your bondsman. Your bondsman will give a notice at this reset date. You're free to go and you have a blessed day.
And you do as well. Thank you.
Okay, you're welcome. Jefferson County Court at Law number 2 is back in session. Court is in session with its arraignment docket. First two cases are cause numbers 25 CCCR 1780 and cause number 25 CCCR 1781. Both cases are styled the state of Texas versus Ricardo David Alvarez Jr. Mr. Alvarez, would you please come forward? Mr. Alvarez, your full name is Ricardo David Alvarez Jr. Mr. Alvarez, would you please raise your right hand? Mr. Alvarez, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Alvarez, you may put your hand down. How are you doing, Mr. Alvarez? I'm doing fine, thanks for asking. Now, Mr. Alvarez, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Alvarez, before you signed and initialed this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Then, Mr. Alvarez, your case will be reset to give you an opportunity to hire your attorney. Our court coordinator is going to reset your case, but before she does that, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard, all of them. You know, one. Staple. Give me some of your staples. Well, I don't have a staple.
Oh, you need a seat.
Yeah.
This one is a seat.
Thank you.
Oh, that's on it.
Hand this document to Mr. Alvarez.
Yes, sir.
Okay, Mr. Alvarez, the document that you have in front of you is titled Standard Bond Conditions in County Court at Law number 2. I'm going to go over these bond conditions with you. And it states, following the return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the addition of conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply because that condition only applies in a DWI case. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by Section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now, Mr. Alvarez, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. You understand? Okay, now, Mr. Alvarez, you're gonna have a seat in that first chair, wait for your name to be called. Once your name is called, you go to the window. And then once you finish at the window, you'll be free to go and you have a blessed day. Thank you. Brett Martin. Cause number 25 CCCR 1744. Yes.
The door is locked, sir. I just, yeah, that's all. Yes.
Yeah, something is over there. So. Okay.
Okay, yeah.
Okay, so that'd be-
Hey, Mr. Martin. Um. Your full name is Brett Martin? Mr. Martin, would you please raise your right hand? Mr. Martin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Martin, you may put your hand down. How are you doing, Mr. Martin? You okay? Well, that's good. Well, Mr. Martin, I have before me two documents, well, one document. This document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to hire your own attorney and have your case reset? Now, Mr. Martin, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Mr. Martin, your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator will, yes, pick this. Our court coordinator will reset your case. You can leave that, thank you. And I have some. Once you reset your case, you'll be free to go. And before she does that, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2, and I will go over that document with you. And this document states that following the return of a criminal information in County Court at Law Number 2, all bail bonds are executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and 4 does not apply. However, on page 2, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Martin, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay, Mr. Martin, please have a seat in that chair on the wall. Wait for your name to be called. Once your name is called, you'll go to the window by the court coordinator. She'll give you a reset. Once your case is reset, you're free to go and you have a blessed day. Sabino Rodriguez Jr. Okay, Mr. Rodriguez, your full name is Sabino Rodriguez Jr. Mr. Rodriguez, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
Mr. Rodriguez, you may put your hand down. How are you doing, Mr. Rodriguez? You doing okay? Well, that's good. Now, Mr. Rodriguez, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Now, Mr. Rodriguez, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Rodriguez, I read your answers. Your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator will reset your case. Once your case is reset, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Here you go.
I'm not gonna give you George.
Hmm. Next case is cause number 25 CCCR 1772, case of style of state of Texas versus Jarrell Dodd. Mr. Dodd, would you please come forward? Mr. Dodd, your full name is Jarrell Dodd.
Yes, sir.
Mr. Dodd, would you please raise your right hand? Mr. Dodd, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Dodd, you may put your hand down. How are you doing, Mr. Dodd?
Good.
That's good. Now, Mr. Dodd, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for, that you would like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Dodd, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge? Mr. Dodd, I read your answers. Your case will be reset to give you an opportunity to hire your own attorney. And our court coordinator will give you your reset. Once she gives you reset, you'll be free to go. But before she does that, the bailiff is going to hand you a document that is titled Standard Bond Condition in County Code at Law number 2. Do you see that document?
Yes, sir.
Okay, I'm going to go over this document with you in the states. Following the return of a criminal information in County Code at Law number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition 3 and 4 does not apply. However, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Dodd, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay, Mr. Dodd, please have a seat in that first chair. Wait for your name to be called. Once your name is called, you'll go to the window and you'll be free to go. And have a blessed day. Tamia Bailey. Miss Bailey, your full name is Tamia Bailey?
Yes, sir.
Miss Bailey, would you please raise your right hand? Miss Bailey, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Miss Bailey, you may put your hand down. How are you doing, Miss Bailey?
Yeah.
I'm doing fine. Thanks for asking. Now, Miss Bailey, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled defendant's signature. Is this your signature? Miss Bailey, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Bailey, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair and wait for your name to be called.
Yes, thank you.
You're welcome. Hannah Smith. Ms. Smith, your full name is Hannah Smith? Ms. Smith, or is Hannah Gail Smith?
My middle name, yeah.
Okay. Ms. Smith, would you please raise your right hand? Ms. Smith, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Ms. Smith, you may put your hand down. How are you doing, Ms. Smith?
Doing well, how are you?
I'm doing fine. Thanks for asking. Now, Ms. Smith, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line as titled defendant?
yes, sir.
And are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
Now, I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Ms. Smith, before you signed and initialed all of these documents that I just showed you, did you read the document? Did you understand what you read? And is everything in these documents true and correct
Yes,
to the best of your knowledge?
yes,
Okay, Ms. Smith, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
yes, sir. Thank you. You too.
You're welcome. Thank you. Do we have any, did they send any things over?
I'm checking.
She's telling me this.
Oh, it's just a dismissal.
When I had asked, she said she did it.
I had 2 people, or 3 people.
Yes, I do have one newspaper.
people look at this here as a stumbling block. But you can look at it as a stepping stone, and people use stepping stones to lift to reach higher heights. And so whatever you want to accomplish in life, you still can reach it. Okay? So, folks, thanks for coming out here with your son and with your brother. I always tell young people this here, and I tell parents this here, don't give up on it. Don't hang up, hang on. Okay? He'll be all right. Right. And so, with that in mind, you're gonna get your dismissal. And, one of these days, you're gonna have yourself in a position where your parents and your mom and your sister gonna come to a place where you will make them proud. Okay? Okay, so you can put all of this behind you. All right, so you have a blessed day. Okay,
Judge, I should dismiss for last page, or your second page for me.
the second page on what?
You know, when you put, approve and I need to.
Oh, they didn't have it? I need a third page on a affidavit of indigence. It wasn't on there.
On who?
Like, on Miss Smith, just third page. You could just take it off of any one of those tablets, any one of those clipboards. The third page was missing. Some of those documents only have 2 pages. It's the third page of the affidavit. No, not that one. The last one,
With the brackets?
right there. Yeah, that's it.
Oh, that.
That's a 3-page document.
You don't have. Just have to.
You should have made this, paperwork. Yeah.
Here you go. Oh, that sounds Smith.
Okay.
Okay, here you go. Here you go. I don't need that other document right here. Jonathan Amador Panita. Mr. Amador Panita, your full name is Jonathan Amador Panita.
Yes, sir.
Would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
That you may put your hand down. How are you doing?
Good, thank you.
That's good. Now, Mr. Amador Panita, I have before me a document that is titled Judge's Explanation of Rights as Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
I also have another document. What is this? This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document? Do you?
Yes, sir.
And on page 2 of this document, is this your signature?
Yes, sir.
Now, Mr. Amador Panita, before you and sign and initial these documents. Did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Amador Benita, I read your answers. Unless something's wrong, I don't think you meet the eligibility requirements for the appointment of a court-appointed attorney. Man, hold on, let me do this. Let me ask you something. You could just, you need to calculate that up.
Yes, sir.
Yeah.
I gave you,
Oh, could you hand it?
yes, sir.
Thank you. Mr. Brett Martin, please come forward. Okay, now, Mr. Martin, I have before me two documents. Document is titled Judge's Explanation of Rights of Defendants Without Attorney. You made a change on this document, is that correct?
Yes, sir.
And is this your signature?
Yes, sir.
And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes, sir.
Have another document that is titled Waiver of Counsel. Hold on a minute. Need to put a court case number on this. Okay. Okay, have another document that's titled waiver of counsel purposes to enter guilty plea of proceeding trial. You recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Martin, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay. Just raise your right hand again. Swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God. Now, Mr. Martin, I have before me a document that is titled Motion to Forfeit Weapon. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Before you sign this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge? Okay, the court is going to grant this motion to forfeit the weapon, in this case, to the Beaumont Police Department. State, you have an additional motion?
Yes, Your Honor, in agreement for the forfeiture of the weapon, the state agrees to dismiss the underlying case.
Okay, Mr. Martin. I'm signing this motion to dismiss. You will be able to get a copy of this motion in a few minutes from our court coordinator. I just signed it. Just have a seat in that chair, wait for your name to be called. Once your name is called, you go to the window and get your dismissal. Once you get your dismissal, you'll be free to go on your blessed day. You're welcome. Martin, yes, Martin. Martin. Okay. Do we have Mr.
It's right next to you, Judge.
Okay. Commodore. She's also over here. Mr. Jonathan Amador Panetta, please come forward. Will be Charles Ross.
Okay, that's the.
Yes, Amador Panetta. Okay, Mr. Amador Panetta, just raise your right hand. Swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay, Mr. Panetta, I have before me a document that's titled Jefferson County Affidavit of Engineers. Do you recognize this document?
Yes, sir.
And on page 2, there's a signature above the line that's titled defendant. Is this your signature? Now, Mr. Panetta, you also have a document that is, you signed a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Is that correct? Is this your signature?
Yes, sir.
And these initials on the line state you want to like to apply for court-appointed attorney. Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Burnett, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Attorney that will be appointed to represent you is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair and wait for your name to be called. There you go. Okay, next case is cause number 24 CCCR 3015, case of style of state of Texas versus Ladris Javon Love.
No, sir.
Okay, Ladris Javon Love was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Ladris Love at the courthouse door. Ladris Love did not answer. A reasonable time has passed to give Ladris Love an opportunity to appear in court. Ladris Love has not appeared in court. The time now is 11:48 a.m. on today's date of September 9th, 2025. Ms. Bailiff, would you please call the name of Ladris Love at the courthouse door?
Ladris Love.
This is a case that was transferred.
No response, Your Honor.
Okay, Ladris Love. Name was just called to get at the courthouse door. Ladris Love did not answer. A reasonable time has passed to give Ladris Love an opportunity to appear in court. State, do you have a motion? That motion will be granted. Ladris Love bond will be forfeited. Warrant should be issued for Ladris Love in cause number 24 CCCR 3015. Next case is cause number M333052. Case is styled the state of Texas versus Joseph Andrew Marks. Joseph Marks was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Joseph Marks at the courthouse door. Joseph Marks did not answer. Reasonable time has passed to give Joseph Marks an opportunity to appear in court. It's not appear in court state. The time now is 11:50 a.m. on today's date. Ms. Bailiff, would you please call the name of Joseph Marks at the courthouse door? That, hear me, please.
Joseph Mark.
No response.
Okay. Joseph Marks' name was just called again at the courthouse door. Joseph Marks did not answer. Original times has passed to give Mr. Marks an opportunity to appear in court. It's not appear in court state. You have a motion? That motion will be granted. Joseph Marks' bond will be forfeited and a warrant shall be issued for his arrest and cause number M333052. And this will conclude the calling of the court's docket on today's date of September 9th, 2025, in County Court at Law Number 2, Judge Terrence L. Holmes presiding. Court will be in recess until 1:30, when we will resume our jury trial. And prosecutors, you are excused.